Federal judge says DHS policy suppressing recording of IC agents is unlawful. IC claims filming is illegal. In January 2026, a federal judge ruled that the Department of Homeland Security, DHS, policy treating the recording of Immigration and Customs Enforcement, IC, agents as unlawful likely violates federal law and constitutional protections, contradicting claims by IC agents that such recording is illegal. The ruling comes amid heightened tensions over federal immigration operations in the Twin Cities and across the country as the Biden and Trump administrations continue aggressive immigration enforcement, especially in Minnesota, where thousands of federal agents have been deployed. What IC has been saying, while conducting immigration operations, often in cities such as Minneapolis and St. Paul, ICE agents have repeatedly told observers and members of the public that it is illegal to follow or record them. Videos posted on social media show agents warning bystanders against filming or live streaming their actions, sometimes branding such behavior as interference or threat. Many observers have reported being stopped or detained while simply documenting federal enforcement actions. These incidents have raised significant First Amendment questions, since recording law enforcement in public has long been considered protected activity under U.S. courts. Federal judges ruling. A federal judge in California recently examined this issue and sided with journalists who argued that DHS's policy suppresses constitutionally protected First Amendment rights, including the right to gather and share information about public officials performing public duties. The judge found that DHS's treatment recording as potential offense likely violated the Administrative Procedure Act and exceeded what federal law allows. The ruling specifically criticized internal DHS directives that appear to frame recording or live streaming enforcement operations as potential civil unrest tactics or threats. Directives that have been cited by federal agents to justify demanding that observers stop filming. Legal implications. Experts say the issue goes beyond semantics. Recording law enforcement officers, even federal agents such as those from IC, is generally protected under the First Amendment when done lawfully and without interfering with official duties. Federal appellate courts have upheld this right in multiple jurisdictions, and judges have repeatedly rejected government claims that filming law enforcement constitutes obstruction absent evidence of direct interference. Advocates argue that efforts to discourage or punish recording by IC agents could chill public oversight and make it harder to document misconduct or civil rights violations. Critics also note that the lack of recording could shield controversial enforcement actions from scrutiny, particularly in raids or traffic stops during ongoing immigration operations. Broader enforcement context. The ruling unfolds against a backdrop of broader legal and political battles over immigration enforcement. Minnesota state and local officials have sued the federal government to halt a large surge of immigration agents, calling such operations unconstitutional and harmful to communities. Additionally, separate legal disputes have arisen around how IC conduct arrests and searches, such as internal memos that may allow warrantless home entries in certain immigration cases. Together, these developments are fueling debate about federal immigration policy, civil liberties, and the balance between enforcement power and constitutional rights.